I'm not seeing her camera. She's over on this side. There we go.
There she is. Hello, Miss Berger.
Hello. Sorry, that seemed like a long delay. I don't know what happened, but.
Well, it's life in the pandemic age.
That's right.
Okay, so have at it whenever you're ready.
All right. May it please the court, Your Honors, my name is Erin Berger. I represent the appellant Victor Oliva in this property insurance dispute with Citizens Property Insurance Corporation. The trial court in this matter granted a summary judgment in favor of Citizens, and we're requesting that the final judgment be reversed and the matter remanded for further proceedings because genuine issues of material fact remained to be determined by a jury in this case. The date of loss in this case was May 10th, 2016. The claim was reported. It was a bathroom leak that resulted in damage to some of the cabinetry and flooring and walls. That was reported about 16 days later. The insurance company inspected the property with Mr. Oliva's cooperation twice in the next couple of months, once in June and once in August. When Mr. Oliva and his counsel hadn't received any response from Citizens after those inspections and providing documentation requested in September 2016, Mr. Oliva requested a determination on his claim. The reasonableness of that request being that under the policy, there's a requirement or expectation that a decision will be made within 90 days. Nothing was received from the insurance company after that until a couple months later when they requested an examination under oath. Mr. Oliva did not sit for the examination under oath by providing an explanation that at the time he didn't believe that it was reasonable because it wasn't necessary for the determination of coverage in this matter. It was something that was requested after some significant delay on the part of the insurance company and wasn't necessary for the determination. The issues that were raised in the initial brief are a couple, Your Honors. First, that the summary judgment wasn't supported by sufficient evidence. And the second being that genuine issues of material fact remain as to whether or not there was a material breach and whether or not there was any prejudice to the insurance company by the non-attendance at the examination under oath. And as I go, if I refer to EUO, I'm referring to examination under oath. I might abbreviate. The motion for summary judgment was supported by a couple of affidavits. One, the affidavit of the insurance company's engineer, Mr. Robert Williams. In his affidavit, he did state, and his report was offered in September of 2016, it's dated, it's in the record, that he was able to determine that there was no evidence that damage occurred due to the reported leak, and noted that there might have been other prior issues that weren't reported that may have contributed to some of the issues that were reported. So there you see in the record that by September of 2016, the insurance company had information available to it to make a coverage determination. The other affidavit that was presented was by the insurance company's corporate representative. The corporate representative attached documents to the affidavit, including correspondence from homeowners counsel, Mr. Oliva's counsel, from its counsel, but made no attempt under the business records exception to the evidence code to authenticate those records, simply stating that these exist, here they are, this is what they say. He didn't claim to have personal knowledge of these issues. Oh, Judge, I think you're trying to speak. There you go.
Yeah, I'm sorry.
That's okay.
I have to unmute myself. I'm trying to understand your argument because your brief, issue 1, is you're challenging the sufficiency of the evidence, saying that the affidavits are inadmissible, but now you're relying on the affidavits to say that there's no prejudice to the insured. I'm trying to understand because below there was no challenge to Citizens' affidavits in any way. No motion to strike them. There was no argument before the judge of them being legally insufficient. So what are you arguing today? That they are?
Sorry.
Are you arguing that they now are legally sufficient?
No, Your Honor, and I'm basically stating to you what's in the record to lay the foundation for my arguments. I'm not suggesting that they were admissible. My arguments are sort of, I guess, in the alternative. If you're
if they're not admissible, then why are you arguing that Mr. Williams's affidavit proves no prejudice?
I don't believe in the initial brief that I argued that Mr. Williams' affidavit was inadmissible. I believe the argument was limited to the corporate representative's affidavit.
Okay.
And that's based on the fact that, again, he's Mr. Melinda, I think was his name, Mr. Melinda, didn't offer any sort of explanation for who he is, what he does, what his duties are, what he reviewed. He just essentially lays out these quote unquote facts, which are essentially hearsay, to suggest that all these things happen, but there's no foundation for his knowledge. There's no foundation for the admission of any of the documents admitted or accepted. The argument, Your Honor's correct, there's nothing I can point to in the record that says that the specific argument that these were insufficient or the documents were unauthenticated. In the response to the motion for summary judgment, there was a challenge to the completeness of the record and whether or not the insurance company met its burden. And Your Honors, in my reply brief, I referenced the case from this court, West Edge 2 versus Kunderas. It's a 2005 case in which this court reversed the summary judgment on the basis that an affidavit in support of a motion for summary judgment was legally insufficient because it was not made on personal knowledge and included unfounded opinions. The main decision or the main opinion that was written in that case doesn't provide this information, but in the concurrence that was written by Judge Silberman, he revealed that this argument wasn't made by the parties in the trial court or in the appellate court or in the briefs, and that he disagreed with the court's opinion on that issue. But there is precedent in this court for applying this court's de novo review to find that an affidavit isn't sufficient to support a motion for summary judgment, even if the parties didn't raise it in the trial court or in the briefs based on that West Edge 2 case.
I'm not sure I'm 100% with you on the conclusion that you reached there. It seems like our court has issued some more recent opinions in the past couple of years, I think in the foreclosure context, that talks about in the summary judgment context that look, if you don't challenge the admissibility of an affidavit, you don't provide us with a transcript of the hearing, you don't in other ways show how you preserved that issue and brought the objection to the consideration and admissibility of an affidavit at a summary judgment hearing. If you don't bring that to us, we're not going to consider it on appeal. I think the law has maybe become a little bit more clear on that in recent years than maybe what you may be suggesting. Am I incorrect?
I don't disagree that those cases are out there. I was providing an alternative argument based on this court's precedent that it does exist where the court can make a determination without the argument being raised below, and providing that precedent for Your Honors to review.
Got it.
Well, isn't the undisputed fact that the engineer came out in August of 2016, and by September, when counsel below indicated they were going to file suit, then that engineer had still not rendered an opinion nor a report. And it's undisputed that counsel below refused to allow them to submit to the EUO.
I believe that there were representations in the record, Your Honor, that counsel did suggest that they would not let Mr. Oliva sit, or they would not coordinate the EUO.
So there's no dispute, they did not submit to an EUO, correct?
Correct, Your Honor. There is no dispute
Okay,
that Mr.
but
Oliva
the policy language that you're relying on for your argument that their conduct was unreasonable under 13 loss payment, paragraph C, with the 90-day provision, whether they accept or deny the claim, has an unless there are circumstances beyond their control. And it seems to be undisputed that when this particular plumbing fixture was repaired, remediated, whatever, a certain part was either lost or discarded. Your client doesn't address that. Your argument doesn't address that. And there's no challenge below in front of the judge that it wasn't lost or discarded. The insurance company is saying, we can't make a conclusive determination because we don't have that piece or part or whatever that is. Why doesn't that exception and the lost payment provision apply here? Because it is beyond their control.
It doesn't apply for a couple of reasons, Your Honor. First, the insurance company was not relying on the show damaged property provision to obtain summary judgment. So that issue wasn't really fleshed out. Second, the claim was reported in May of 2016, and if Your Honor is taking the date of the report being in September of 2016, we're already beyond that 90 days. So there was nothing in that first 90 days beyond their control that they've proved on the record. It was that they didn't take the actions within those first 90 days to reach that conclusion. And in fact, with the engineer's report, he suggested that even if they had that, he would still conclude that the damage wasn't caused by the purported leak. So by that time, they had the information available to them to make the coverage determination and didn't, and then requested the EUO to create a basis to deny the claim. And the argument here being that the basis upon which the insurance company sought and obtained the judgment was that there was not compliance with the EUO. The insurance company has to prove that this was a material breach, which, I'm making the argument that, or we've made the argument that it's not a material breach because they had the information available to them to make the determination before they even requested the EUO. The EUO wasn't necessary for them to make the determination, which is the basis upon which they are claiming that they're requesting the EUO, that they needed it to make the determination. The second being that because they had the information available to them, Mr. Oliva's non-appearance at the EUOs did not create any prejudice to them.
Well, the insurance company was denied twice when they went out to the home. They were denied an opportunity to talk to your client by the public adjuster. So they weren't able to get his statement, but yet you file an affidavit from Mr. Rivero where Mr. Rivero avers and relies upon the statements of Victor Oliva in forming his opinion. Well, the insurance company never got a statement from your client to rely upon.
Your Honor, my client offered to do a telephonic recorded statement, and insurance citizens never took them up on that.
But the policy requires a recorded statement and an EUO, not or. Requires both. It's expressed in there.
It does say and. But again, we would state that and argue that the non-compliance here was not a material breach. The other information was provided. All the documents that were requested were provided. The inspections took place, and he otherwise complied within that first 90-day period to comply with the investigation. The case relied upon by the insurance company to suggest that and the case is relied upon in the answer brief, to suggest that there's no question that the court has to consider the materiality or the prejudice to the insurance company here are distinguishable and predate many of the cases cited by Mr. Oliva in the initial brief and the reply brief. Particularly, the insurance company argued that there is no reason for this court to consider prejudice because this court hasn't required that in any of its decisions. And I would point this court to the decision in Curtis versus Tower Hill, in which the court specifically states that an insurance company must prove or must demonstrate, there must be a demonstration of prejudice. And that there's a case also that the Curtis decision cites to the American Fire and Casualty versus Colora. That's a 1964 case. And in that case as well, there's a requirement that the court consider prejudice to the insurance company. And I don't believe that was done here. There were questions of material fact that remained because the record doesn't demonstrate that certainly there is no dispute that Mr. Oliva did not appear for the EUOs, but there's more recent case law that suggests that the court can look and should look beyond the non-appearance as the end all be all of the argument and look at the circumstances surrounding his non-appearance. There's a recent case that I cited in my reply brief, Your Honors, the Abdo case from the 3rd DCA. where the court concluded that there has to be compliance to some degree or an explanation for non-compliance, creating a genuine issue of material fact as to whether the breach was material and whether it was willful. And I don't believe the record supports a willful refusal by Mr. Oliva here. And perhaps there was a misunderstanding on his part or bad advice given by trial counsel to not appear. But I don't believe that he ever himself or that the insurance company proved that he himself willfully refused. And in that case, in the Abdo case, Your Honors, the court concluded that the insurance company had to prove that the insurer had actual notice that the EUO was requested.
Ms. Berger, you didn't mention whether you wanted to reserve rebuttal, but you're a little over 15 minutes into your argument at this point.
I'll reserve the last few minutes of my time, Your Honor. Thank you.
Okay, thank you. Sure. All right. Bober.
Morning. May it please the court. My name is Carl Bober. I represent Citizens Property Insurance in connection with this case. It has been the settled law in Florida for decades that an outright refusal to comply with an insurer's request for an examination under oath in a homeowner's property insurance case is a material breach of the insurance policy, which precludes recovery under the policy. The duty to sit for an EUO and the policy provisions related to them in a homeowner's insurance contract have similarly been considered conditions precedent to the bringing of a suit, rather than cooperation clauses, so that an insured's failure to comply with the request to sit for an EUO precludes a cause of action by an insured regardless of a showing of prejudice. The Goldman case cited in the materials going back to 1995 in the 4th District makes this clear, and it's cited in our materials. And the Amica versus Insurance versus Drummond case from this court in 2007, which relied on the reasoning and rationale of the Goldman case, is that a outright failure to comply with a demand for an EUO is a willful and material breach of an insurance contract, precluding recovery by the insured. Every case that the insured even suggests, the appellate in this case suggests about cooperation, they do not cite a single case in any of their authorities where there is just an outright refusal to sit, as there was the case here, for an examination under oath. If you look at every case cited by the insureds, it's in almost every case, the insureds either said, I didn't know that I had been asked to sit for an examination. For example, in the I'm going to butcher the pronunciation, Macrillos versus Citizens case, that case wasn't even an EUO case. They cited it as an example of partial compliance. It was involving an insured who belatedly submitted a sworn proof of loss. In the Himmel case, the insured that the appellant relies upon, the insured wanted to attend the EUO, offered to attend the EUO, and requested to reschedule for a mutually convenient date and time due to unavailability, and evidenced his attempts to comply with the request for EUO. And in that circumstance, the court held, well, that could create a question of fact about whether the compliance was willful or not. In the State Farm versus Figueroa case relied upon by the appellant, again, that's a proof of loss case, not an EUO case, where the submission of the proof of loss was untimely. And again, as a condition, the court said that could create a question of fact. In Nawaz, N-A-W-A-Z, cited by appellant, the insurer tried to exclude the insured's public adjuster from attending. But in every instance, every case cited by the appellant, the insured is attempting to cooperate. They're attempting to provide the proof of loss. They're attempting to sit for examination under oath. They cite not one case where the insured says, I just don't think I'm coming. I don't think it's reasonable, and I don't think I'm coming, and I just refuse. Every case cited by the insured involves, and then by the appellant here, involves a situation where they either attempted to come, Himmel also, well, I mentioned Himmel. All these cases involve that circumstance. So now turning to the facts of this particular claim, Um,
Well, while you're looking, let me ask you this question.
Yes, sir.
Below, did the appellant dispute notice of the EUO?
No, to
They're
the
in-
sorry,
They're in
Judge.
the record.
Yeah, to the contrary, on page 278 of the record, counsel for the appellant says, we would characterize as 100% the plaintiff did not sit for his requested examinations under oath.
Okay, so let's talk about the cases that you've cited in your favor, because we do have the Drummond case where in 2007, this court did find that the EUO is a condition precedent and failure to submit to that is a willful and material breach. But we've never really addressed prejudice. And the fourth seems to be going that direction. Now, the fifth has certified conflict with Goldman, but the Supreme Court didn't address it in Curran, but Curran's dealing with an IME or a CME. I'm not so sure that those are equivalent, but in Estrada, the third DCA has certified conflict with Goldman. That's a failure to submit to an EUO. And they find that that is presumptively prejudice, and then they put the burden on the insured to prove prejudice. Why can't we consider prejudice in this particular case? Because there is evidence they allowed the home to be inspected a couple of times and did, submitted documentation.
Judge, well, first, with respect to Estrada, the third district, number one, reaffirmed that the failure to comply with the post-loss obligations and material breach of the policy. I believe I'm quoting from the policy when I say it says, it confirmed, the well-established precedent holding that an insured's post-loss obligations set forth in insurance policies are conditions precedent to suit. And I
agree with that. But my second point about Estrada was this. They certified conflict with Goldman and they agreed to follow Farmer out of the fifth, which requires the insured to prove prejudice under those circumstances.
I'm not sure.
It's already presumed.
Yeah, I'm not sure about the conflict issue on that basis because it draw distinctions with those arguments. It drew a distinction with the current case, which, as the court noted, is a UM case involving a CME provision. The reasoning of Estrada embraces the holding of Amica and the Hunt versus State Farm case, also out of the fourth district. So the third, the second, and the fourth, I believe, are all on the same way of thinking to this, that this is a condition precedent and a failure to attend is a material breach of the insurance policy. There were a lot of other issues going on in the Estrada case outside of EUOs. There was fraud allegations. There was a multitude of other issues that didn't speak to the examination under oath requirement.
Well, Ms. Berger's also alluded to the fact that Mr. Williams or the engineer's affidavit, although he does state that there was a missing component that might prevent him from making a conclusive opinion, he then states in the next paragraph, however, I was able to determine that there was no leak there or any damage. Does that create an issue of fact, or does that show that you weren't prejudiced? Tell me about that.
No, sir. I don't agree with the appellant's interpretation of the meaning of the engineer's findings. What the engineer said was he asked for and wanted to see the plumbing. Keep in mind, Citizens was out there, even according to the plaintiff's, the appellant's affidavit, within 4 days after this loss was reported, the plumbing part was gone. But not only the plumbing part, the damaged property, the baseboards had been ripped out, and all that damaged property was disposed of and not available for neither the adjuster nor the engineer's inspection. So he basically said, I want to see these things. I can't tell you what the cause of loss was because I was deprived the opportunity by the appellant or someone on the appellant's behalf to examine these things. While I was there, I saw no evidence consistent with the reported leak. But he doesn't know what he doesn't know because he hasn't been given the opportunity to see the plumbing part, which he requested to see. He hasn't been given the opportunity to see the property that was damaged, that was gone within 4 days after the claim was reported to citizens without explanation. So he has no way. So yes, he did say he didn't see evidence consistent with the reported leak, but of course he hasn't been provided all the evidence, which leads us to why citizens needed to have an examination under oath of the insured. It could not speak to the insured. It was deprived the opportunity, even though it's a duty under the policy, to show us the damaged property, to see the damaged plumbing, gone within 4 days by the time the adjuster's there without explanation. The damaged property is ripped out of the wall and gone. And so we asked to see it. The adjuster can't come to a conclusion. We hire an engineer. The engineer's report says, I need to see this information, so I can't come to a definitive cause. We ask for a recorded statement, which is provided for under the policy. And keep in mind, the recorded statement is part of a provision that says we need to do it and outside the presence of the insured. And they said, well, you can do it telephonically. Well, there's no real, maybe via Zoom, but over the phone, there's no way to independently confirm who you're speaking to, let alone that they're outside the presence of any other potential insured, which is also provided for under the policy. So that is really not an offer of compliance with the policy. And it was only after that point, after 2 inspections, attempts to speak with the insured over the course of a period of months, that the carrier, if they were going to try and figure out what happened, and by the way, when they got there, they saw no evidence of damage other than from the water mitigation company. The water mitigation company had ripped out the wall, drilled holes in the cabinetry, but they didn't see any evidence of it. So they needed to speak to the insured to say, what did you see? What evidence did you see? Did you see the damaged baseboards? Were they wet? Were they damaged? Why were they disposed of? Where are they? Do you know what happened to them? So that we can perhaps independently inspect this damaged property ourselves, or our engineer can, so that he can come to a conclusion about whether this was due to a covered cause under the policy or not. These were all reasonable questions and reasonable reasons why the carrier needed to speak with the insured about his claim, since having exhausted all other means, from inspections to requests to recorded statements, they could not ascertain the information. So at that point, it's clear from the record also that the decision not to participate wasn't some, unlike all the other cases cited by the appellant, where the insured is trying to cooperate, either providing the information belatedly or offering to come to an EUO, but they don't want to do it at one of the cases that is cited by the appellant is that there was a dispute over the location of the EUO. Insured's willing to give it, but not at the insurance carrier's attorney's office. Or one of the cases cited by the carrier was the insurer said they were going to request the EUO, but never scheduled it. And then they denied the claim on that basis and tried to defend, and the insured offered post-suit to say, yes, I'm still willing to sit for the examination under oath. None of those things occurred here. Not one time did the appellant offer. Rather, it was made quite clear in the record by his counsel's argument that he wasn't coming. And he wasn't coming because he decided that 90 days, according to him, just justified that the carrier was now forbidden under the policy from taking the examination under oath, notwithstanding the fact that there were clearly things outside the carrier's control which prevented the carrier from being able to complete its investigation, such as the disposal of the plumbing, such as the disposal of the damaged property, such as the denial of the opportunity to have a recorded statement in person with the insured. Those were things that the carrier sought within the 90 days, but was deprived of, and unfortunately delayed its investigation. The only way the carrier could truly find out from its own insured what happened here was to speak to its insured, and the policy provided the opportunity and the means for them to do that via an examination under oath, which per the appellant's counsel, he refused. There was some suggestion by counsel that perhaps that wasn't good advice. I agree. They cite no authority that somehow bad advice from counsel creates an excuse to comply with your obligations under the policy, nor is there any authority for such a proposition, which the trial court noted as well in the record. So it's our position that the case law is well settled, relying upon this court's holding in the Amica case, in the Goldman case, and I would submit the Estrada case, that there is that failure to comply with a post-loss obligation is a condition precedent to suit. The fourth, the third, and the second, and the third most recently in 2019 have embraced that position. As far as the arguments about the affidavits, I don't know that I need to spend a lot of time on it, because the truth of the matter is that the sufficiency of the affidavit is really irrelevant in this case. The issue about the affidavits are whether the carrier's letters were authenticated or not. There was a stipulation at the trial court by counsel for the appellant that these were received. These were 100% requested, and 100% the insured did not attend. And of course, no objection was made, no motion to strike them if there was going to be some argument had, other than for the first time on appeal, that those records were either not authentic or shouldn't be considered as competent summary judgment evidence. As far as the argument about material fact, again, in its brief, the appellant argues that somehow that there's insufficient evidence of record to establish that the EUO was requested. And of course, the plaintiffs, by the way, to remove any doubt about the matter in terms of competent evidence, the plaintiff's own verified affidavit in this case attests to the fact that his examination was requested, but that he chose not to appear because he didn't construe the policy to require it. So that argument is just refuted by the record. And again, all the partial compliance cases, there's not a singular partial compliance case cited by appellant's counsel where there is an outright refusal to appear for an examination under oath, such as the case as here. Every case involved the insured offering to sit, but under circumstances that were not acceptable to the carrier, arguments over the location of the office, or whether, or they cite a lot of cases that don't have to do with examinations under oath, such as untimely compliance of sworn proofs of loss, which is not the case here. So for those reasons, I would submit to the court that the trial court got it right, and that the court's summary judgment entered in favor of citizens must be affirmed.
Okay, thank you. Ms. Berger?
Thank you, Your Honors. Just briefly, as I mentioned in my initial argument, the Amica or the Drummond and the Goldman cases suggest that there's a strict rule to be applied here. I think the cases that have come down from the various district courts since those cases came down suggest that it's not a strict rule of exclusion, but that there are circumstances under which the non-appearance at an EUO or compliance with other post-loss conditions, including the sworn proof of loss and other things showing the damaged property, can be looked at in the totality of circumstances kind of way to suggest that there's not material breaches when this happens, or that there's been no prejudice that would result in the forfeiture of coverage.
But Ms. Berger, let me just ask you, because I think you need to concede that every case that you've cited, and even the case Solano, where Judge Warner wrote on the rehearing about her, her doubts about whether an EUO is a condition precedent, even those cases, the insured agreed and it was set up. It just didn't happen. In Solano, actually, Dr. Solano showed up and gave the EUO, but he refused to allow his wife to submit to every single case that you have. It was set up and somehow didn't happen, or it was partially done, but the insured agreed in every case. In your case, absolutely refused.
I agree that the cases are as they read and as they state, that there has been a coordination, or there was, an offer to do it and we never heard back from the insurance company. But my argument here is that there's room in this case to make a similar argument that there is an element of partial compliance or sufficient explanation for the reason not to, because essentially what's been created here is an impossibility for Mr. Oliva to comply, because what you have it in the arguments being made here by the insurance company's counsel, if the issue is that he can't produce that plumbing piece ever, taking the EUO is not going to cure that.
Well, we could they could have at least heard him say that under
Correct.
oath.
But they also, you know,
But
the
Mr. Stream's firm didn't allow it, period, at all.
right. And to that argument that insurance companies counsel made, that, you know, we've offered no authority to suggest that a situation created by counsel can't be a reason to find that there hasn't been a material breach by the insured. I submit to you the Abdo case that I cited in my reply brief. And to the argument that was made by insurance companies counsel that they exhausted all other means. I mean, here you haven't seen that they requested the sworn proof of loss, that they took them up on the offer to prepare the recorded statement by telephone. The policy does not require an in-person recorded statement. You know, they haven't demonstrated that they tried to get the information about where the plumbing pieces were from from Ayers, from the company that did the work. So, I mean, the argument here is that they've created an impossible situation. Mr. Oliva could not, you know, he probably didn't know that he was supposed to ask Ayers to retain these pieces and these plumbing parts, because he asked them to do a job and they did it. You know, he may not have known to if he hadn't had any sort of insurance claim before, what exactly he was supposed to retain or how it was supposed to be presented. And if it was supposed to be that he called the insurance company first. But he did what he could here. He supplied all the information. He did mitigation to prevent further damage, which is another condition under the post-loss obligation provision. He allowed inspections. He offered to do a recorded statement, you know, and by the time that they requested this, months after the claim was reported, he didn't state that he refused. Sure, there's on the record, it seems that counsel for Mr. Oliva did suggest that he would not let him sit. But I think the affidavit that's been presented says, they requested it. I didn't think it was reasonable. I didn't think I had to. And again, this might be a question of whether or not this was something that was created by, you know, situation that was created by counsel, is how I can phrase it. But, and I don't know that there was a stipulation to anything in the record about whether or not sorry, I forgot. I lost my train of thought there. Again, Mr. Oliva would just request that if this court would find that the affidavit was insufficient to demonstrate that they requested these things requested the EUO because the documents weren't authenticated, there was no material breach, and that there was not an appropriate review of whether or not the insurance company was prejudiced, that your honors would agree and reverse and remand for further proceedings.
Thank you, Ms. Berger.
Thank you.
For you guys to leave this virtual courtroom, you need to click the leave button in the lower right corner of your Zoom screen, and then you'll be gone. We'll call the next case.